Welcome aboard, applicants. We're continuing now, excuse me, in the Lewis Ella and Sarah Ella contract law question 2 of the first year law students examination baby bar, October 2019. Now, second call the question where we left off was what contract rights and defenses, if any, do Ella and Sarah have against one another regarding the $7,700 and $5,500 prices, and who is likely to prevail? Discuss. So, going back and reading the pertinent facts to our call, at that moment, Sarah, another customer, approached Ella. A week earlier, Sarah had hired Ella's garden to redo Sarah's landscaping specifically in preparation for the wedding of Sarah's daughter. The comprehensive written contract, which does not mention the wedding, specified a $7,700 price for extensive work including weeding and trimming, walkway placement, and the purchase and installation of numerous plantings. Subsequently, Sarah's daughter canceled the wedding, and Sarah no longer wants Ella's garden to do the work. Sarah told Ella that she would go forward with the contract, though, if Ella would do the work for significantly less money, that is $5,500, and Ella very reluctantly agreed. Now, at this point, we should be looking at what is our applicable law, following our shopping list, our checklist, and make sure to feel free to put in your own shopping list, put in your own checklist at this point. Formation, third party, performance, discharge issues, breach, and remedies. Okay, now going through our formation issues, our first formation issue would be the applicable law. Looking into these facts, I'm seeing that we're dealing with right here, we're dealing with a contract concerning weeding, trimming, walkway placement, installation of numerous plantings. So let's highlight this right here so we can pull this to our attention. Weeding and trimming, what does that sound like? Does that sound like a sale of a good to you? No. Does it sound like more like services? Absolutely. So that's one for common law. Two, walkway placement. Does that sound like a good sale of a good? No. Does it sound more like common law services? Yes. Two for common law. And three, the purchase and installation of numerous plantings. Now, the purchase of numerous plantings would qualify as our Uniform Commercial Code sale of goods $500 or more, but maybe the installation of numerous plantings would more qualify as common law services. So we technically have the situation down here under our applicable law, right down further here, under Ella and Sarah, applicable law. We want to make sure to call out to the attention of our reader that the UCC governs the sale or transaction in goods. Goods are movable, tangible, personal property at the time of contract formation. Okay. We also want to make a mention of common law at this point too. Common law governs contracts. Governs contracts concerning services, land sale or sale of an interest in land, and intellectual property. Okay. Here, the contract between Ella or E and S, Ella and Sarah, concern what now? Let's take a look. Come back up to our facts. It concerned weeding and trimming, walkway placement, purchase and installation of numerous plantings. come down here, concerned weeding and trimming, walkway placement, and purchase. I want to make sure that this purchase and installation of numerous plants, I want to make sure that that's correct. Purchase and installation of numerous plants, exactly. Okay. Okay. At this point, we want to indicate to our reader too that we're dealing with something called the predominant factor. When there's a predominant factor, we're looking to what is it that the contract predominantly pertains to. Now, we're going to say under the predominant factor test, the contract between E and S concerned more services because, or say lawn services, let's see, make sure that we got, okay, predominant walkway, there we go, okay, because the contract only incidentally dealt with the sale of plants through the purchase of plants. However, because the contract has both UCC and common law parts, we should deal with each, we should deal with each area, or each area, or we should deal with each law in its appropriate area in the contract. There we go. Thus, the contract will be governed by both UCC and common law. However, the common law would predominate the contract. Okay. All right. Now we're at an interesting point. Some fact patterns, some questions, have this phrase in it, and we'll bring it out here: a comprehensive written contract. Since we're still in formation, whenever we see this, there has been what? Mutual assent, consideration, and no applicable defenses to contract formation. But how do we deal with this phrase, comprehensive written contract? Well, we want to first note our header, comprehensive written contract, which indicates that we have read the material, read our question or read the facts from our question, and are applying them in our written answer right here. Comprehensive written contract. You probably want to even go so far as to say contract formation, colon, or I like this is another one too. Contract formation, comprehensive written contract. And we want to possibly throw in our rule statement for a contract as well. Contract formation, requires valid offer acceptance consideration without applicable defenses to contract formation. Here, we want to indicate the facts state that Ella and Sarah have a comprehensive written contract. Okay. Now, we want to make sure, though, that we're pulling into our application all relevant facts from our question. Now down here, when it says, or up here, it says, which does not mention the weeding, specifically a $7,700 price for extensive work including. Okay, so now we want to make sure that the $7,700 price is included in there. You might say this down here. The terms of the written contract include a $7,700 price for lawn. Let me go up here. I think it's. Let me double check here. I want to make sure how the question words this. Does not mention the weeding, specifically a $7,700 price for extensive work. Okay, for extensive. I want to say. Trying to see if it's lawn work. Gardening work, extensive gardening work. Okay, I could probably put that in there. Okay. However, the contract does not mention the wedding. Okay, period. Thus, S and E have, actually, you probably should pull this down here so we can show our IRAC. S and E have a valid comprehensive written contract. Now, after formation, we're going to be going into the performance stage of our contract. At this point, we want to make sure to quickly go through our facts yet again and make sure we're pulling in all the facts that would, or I should say this, that we're pulling in all the issues that the facts trigger through our issue spotting. Subsequently, Sarah's daughter canceled the wedding. Now, we already know up here that Sarah, another customer, approached Ella. A week earlier, though, Sarah had hired Ella's garden to redo Sarah's landscaping, specifically in preparation for the wedding of Sarah's daughter. Okay, so the comprehensive written contract, which we've already talked about, does not mention the wedding, specifically a $7,700 price for extensive work including weeding and trimming, walkway placement, and purchase and installation of numerous plantings. Subsequently, Sarah's daughter canceled the wedding, and Sarah no longer wants Ella's garden to do the work. Sarah told Ella that she would go forward with the contract, though, if Ella would do the work for significantly less money, that is $5,500, and Ella very reluctantly agreed. Now, at this point, what would this be considered? Well, I'm seeing a modification here. And because we have both the Uniform Commercial Code and the common law governing our contract, we want to approach our modification from both of these laws. So let's do that. Okay, right down here. Okay, and then modification. Common law. Okay. Under the UCC, a modification generally requires the modification to be made in good faith and contain mutual assent from both contracting parties. Okay. Here, the facts state that Sarah had contacted Ella's garden to landscape for Sarah's daughter's wedding. Let's see here. What? Yeah. Okay. Okay. Make sure I got this correct up in the facts here. All right, right here. Sarah's, okay, right here, had hired Ella's garden to redo Sarah's landscaping. Redo Sarah's landscaping specifically in preparation for the wedding of Sarah's daughter. Facts state that Sarah had contacted Ella's garden to redo landscaping in preparation for Sarah's daughter's wedding. Maybe I want to make sure I'm saying that right. Okay, right here. In preparation for the wedding of Sarah's daughter. Right here. Okay. When you put in that you are both using common law and UCC, how do you differentiate them in your discussion as to not confuse your reader? Well, that'll be when we bring that that out in our this one here. We're going to be bringing that out in terms of the common law is going to have a need for new consideration specifically, and the Uniform Commercial Code is going to be mainly requiring good faith. And that's what we're going to say is whether or not under the common law there was new consideration, which, just to kind of fast track this for a minute, it's probably not going to be there because of the pre-existing duty rule. But under the Uniform Commercial Code, oh, I thought that you had to pick one, not use both. Well, that's why we're entertaining both, and that's to show our reader that indeed we have a contract that has parts parts UCC, parts common law. Yeah, here the facts state that S had contacted Ella's garden to redo landscape preparation for the wedding of Sarah's daughter. However, Sarah will argue that due to her daughter's canceled wedding, she no longer needed Ella's landscaping services, but would still contract with Ella for a significantly lower price. So are you saying that if UCC, then it would go this way, and if you use common law, then it would go that way? Yeah, that's correct. That's correct. See, right here we're looking to see if is this. See, Ella may argue that this price change was not made in good faith because Ella did not know about the wedding at the time of contract formation, and that the price is a significant lower price for possibly the same landscaping service. Okay, here we go. Oh, yeah. Yes. Sarah will counter argue that the price change was in good faith because she is still willing to contract with Ella for the landscaping services. And since Ella reluctantly agreed, though I was going to say though reluctantly, the court may find that both parties have acted in good faith How do the flowers play in here? Well, that's a very good point. Let's go up and take a look at that. So this is Sarah. Okay, subsequently, Sarah's daughter canceled the wedding, and Sarah no longer wants Ella's garden to do the work. Okay, now Sarah told Ella that she would go forward with the contract, though, if Ella would do the work for significantly less money, that is $5,500, and Ella very reluctantly agreed. I don't see there being any flower. Okay, the flowers. See that's the installation of numerous plantings. See that's an interesting. That is a very good observation. That's what brings us into the modification through the Uniform Commercial Code. That's exactly right. So what we're saying is that Ella is going to say, well, this is not in good faith because I didn't know about the wedding at the time of contract formation. So how can we be changing the price on something that I didn't even have notice of at the time of contract formation? Something I should have been made aware of. Now we got Sarah saying, well, I don't need the contract anymore, but because of the wedding being canceled, but I'm still willing to go through with the contract. I'm still willing to go through with our contract, but I want to reduce the price from $7,700 to $5,500. And the question is, has both parties acted in good faith? And has there been mutual assent between the parties? Now, since this is the whole thing, since Ella agreed, though reluctantly, and Sarah is still willing to contract with E, the court may find, or will likely find, that both parties have acted in good faith with sufficient mutual assent. Now, this is definitely just an interpretation on the facts, and we're just trying to pull out our analysis, our application, and applying it to our elements. First of all, we lead with the fact statement that S had contacted Ella's garden to redo the landscaping in preparation for the wedding of Sarah's daughter. However, Sarah will argue that due to her daughter's canceled wedding, she no longer needed Ella's landscaping service, but would still contract with Ella for a significantly lower price of $5,500. Now, Ella may argue that this price change was not made in good faith. Why? Because Ella did not know about the wedding at the time of contract formation, and that the price is a significantly lower price for possibly the same landscaping service. Possibly. S will counter argue that the price change was in good faith because she is still willing to contract with Ella for the landscaping services. Since Ella agreed, though reluctantly, and Sarah is still willing to contract with Ella, the court will likely find that both parties have acted in good faith with sufficient mutual assent. So it's possible that there would if the UCC governs the contract, we might have a possible valid modification here. Now, that may not be the case if we switch gears and go into common law. Now, modification under the common law, modification requires new consideration and mutual assent. Here, Sarah, or I should say Ella, will argue that there was no new consideration in their agreement because Ella was still under a pre-existing duty to perform landscaping services for S for the landscaping services for S for the $7,700 price. However, Sarah will counter argue that her need for the landscaping services in preparation for her daughter's wedding was no longer needed due to the wedding being canceled Sarah will argue that the change in, you might say, the change in circumstances represented the needed new consideration because Sarah was still willing to contract with Ella for the changed price of $5,500. Okay. This is where I believe Ella will prevail here. Now, it appears that Ella has the stronger argument because pre-existing duty cannot supply the needed new consideration requirement. Even if Sarah can argue that Ella agreed to the new arrangement, Sarah would be hard-pressed to argue that pre-existing the pre-existing duty for the prior landscaping agreement was in fact new consideration I'll probably see. Yeah. Okay, now, with that being said, we're probably going to say at this point, thus, modification under the common law would fail, or say would actually, well, the court will likely find that modification under the common law would not prevail. We want to make a conclusion up here. Thus, the court. Oh, actually, we already have that. Okay, great. Okay, great. Now, coming down, we want to make a couple final arguments and then conclude. We're going to go into frustration of purpose. You might be asking, where is he getting frustration of purpose from? Let's come up here and take a look again at the facts. Well, because of the cancellation of the wedding, Sarah might argue that her duty to perform what? Paying Ella the contract price, either $7,700 or the $5,500, is or would be discharged under frustration of purpose. Now, where is the frustration of purpose facts? Where are they, I should say? Sarah's daughter canceled the wedding. This is exactly where we're looking at here. How do you label frustration of purpose? Exactly. We label it just like this, and we'll come back up and take a look at the facts again. Right here. Frustration of purpose, or you could say discharge of duty to perform. Frustration of purpose. Oh, let's see here. Perform. Let's see. There. Now, exactly. Do you also do impossibility and practicability? Well, that's an excellent argument. The thing about it is, we might not in this instance, because I'm trying to find. You know what though? I would throw those in. So let's do that. Let's do that. Frustration of purpose, impossibility. For Sarah, exactly. And impracticability. Excellent, excellent spot there. And then down here under, we want to make sure to throw in a conclusion. Now, at this point, discharge duty performed, we could say that, or yes, exactly. Probably wanted to. We could take this out and just throw in frustration of purpose and be absolutely right as rain. Now, for frustration of purpose, a duty to perform may be charged due to frustration of purpose when the basis of the contract has been frustrated beyond repair. Now we want to make sure under impossibility, we'll throw down a rule statement for that. A duty to perform may be discharged when the performance is no longer objectively possible to perform. Down here under practicability, a duty to perform may be discharged when the performance is financially or commercially impracticable to perform. We want to throw in some the contracting party assumes the duty of market flux and changes. Okay. Okay. Make sure here. Now, coming up here now, we're going to take a look at our facts again. Right here. Subsequently, Sarah's daughter canceled the wedding and Sarah no longer wants Ella's garden to do the work. So that's pretty much the fact that we're looking at. So Sarah no longer wants Ella to do the work due to the wedding being canceled. But it's actually, are you going to discuss exactly? Right here. Let's take a look. Now I ask, has the purpose for contracting been frustrated beyond repair? In other words, is it not even, is the purpose, the basis of the contract no longer there? I would say no on that one, because the purpose was what? Landscaping. Can Sarah still use possibly landscaping services provided by Ella's garden? Yes, exactly. Okay, so here Ella may argue, or I should say Sarah may argue that due to the wedding being canceled, her purpose, I should say this, yeah, her purpose for contracting had been frustrated. However, Ella will counter argue that Sarah's, let's say will argue that the contract's purpose of providing landscaping services to Sarah had not in fact been frustrated because Sarah, like we said, could still use Ella's landscaping services in some form. Yeah, S will gain a new back. Exactly, it's right. We'll say i.e. new and improved backyard. Here we go. Now, thus, Ella, maybe give her a new. Oh yeah, there we go. New and improved backyard with improved home value. Here we go. Thus, the court will likely find that Ella, or I should say this, that the contract had not been frustrated. Or the court will likely find that Sarah will be unsuccessful in proving the contract had been frustrated. Unsuccessful. Let's see. Okay, here we go. There we go. Now, impossibility. Here, Sarah will argue that due to the wedding cancellation, it would be impossible for her to perform. However, Ella will argue that she stands willing, ready, and able to perform the landscaping services. Thus, impossibility will not provide Sarah a reason to discharge her duty to perform. Here, Sarah may argue that her duty to pay Ella should be discharged because, because the wedding was no longer going to take place. However, Ella will argue that Sarah assumed the risk that the wedding would be canceled, and Ella will argue that Sarah she cannot change the price. Well, that was in our modification argument. Okay. Assume the risk that the wedding would be canceled. Also, Ella will argue that S performing her duty to pay Ella for landscaping services would not cause financial or commercial hardship to Sarah. Thus, court will likely find that Sarah will be unsuccessful. Sarah's practicability argument would fail, would be unsuccessful. Okay, now reaching a conclusion here. In conclusion, if the court finds that the uniform, or so the UCC governs the contract, then the contract price may be adjusted in good faith to or from $7,700 to $5,500. However, if the court finds that the common law governs the contract, then the contract price will remain the intended $7,700. All right. Excellent job, applicants. And with that, I will say adieu. And until next time, best of luck on that bar exam.